23-11, Racing and Front Row Motorsports lost a crucial court challenge on Thursday, potentially forcing them to participate as open teams for the rest of the 2025 season. And it would be a severe setback if one of the participating teams departed the sport, or worse, were banned soon. On May 9th, the United States Court of Appeals, in Richmond, VAR, heard arguments from the lead attorneys for both NASCAR and the race teams, as the sanctioning body attempted to overturn the preliminary injunction given to 23-11 Racing and Front Row Motorsports in December of last year. The injunction allowed the two teams to compete against charters without being subject to the release, right to sue NASCAR, specified in the 2025 charter agreement. They attacked the agreement for include these provisions, claiming they constituted antitrust breaches when paired with other circumstances. On Thursday, the United States Court of Appeals ruled in favor of NASCAR and overturned the injunction. This will not take effect for at least 2 weeks because the teams can request another hearing. However, if it is upheld, both 23-11 and FRM will be forced to race as open teams without charters for the remainder of the season. If the teams do not request a rehearing, the final ruling will be effective on June 26th, 3 weeks from now. During last month's hearing, team attorney Jeffrey Kessler tried to argue for irreparable harm, claiming that it is not economically viable to have to qualify each week. According to him, racing as open teams, forced to qualify on speed each week, would be a significant financial strain, potentially endangering sponsor partnerships and driver contracts. Finally, it may have a negative impact on their on-track performance while denying them the benefits of the charter agreement that their championship opponents continue to receive. It's worth noting that only one Cup race this year has sent vehicles home due to field size, the Daytona 500. The Coca-Cola 600 also had a full field, but no vehicles were sent home that day. Both 23-11 and FRM have 3 charters each. Things get even more complicated when you consider that they used the courts and the now vacated injunction to buy a charter apiece from the now defunct Stewart-Haas racing team, adding a third entry for 2025. During the hearing, the justices questioned Kessler on the grounds of the injunction, saying there was no reason for them to benefit from the 2025 charter agreement while confronting NASCAR on its specifics, pointing out that this case is unprecedented. This was cited in Thursday's judgment as a basis for the ultimate conclusion, which noted that Kessler's antitrust theory is not supported by any case of which we are aware. The U.S. Court of Appeals also concluded that the teams failed to make a clear showing that they were likely to succeed in their argument. Therefore, the injunction was lifted. The trial date for the lawsuit is set for December of this year, after the United States Court of Appeals for the Fourth Circuit reversed the preliminary injunction that granted both teams charter status. 23-11 Racing and Front Row Motorsports issued statements. Jeffrey Kessler, the attorney for 23-11 and Front Row, announced that they want to go to the next round of the trial in December. We are disappointed by today's ruling by the 4th District Court of Appeals and are reviewing the decision to determine our next steps, Kessler said, per Bob Pockris of Fox Sports. This ruling is based on a very narrow consideration of whether a release of claims in the charter agreements is anti-competitive and does not impact our chances of winning the trial scheduled for December 1st. We remain confident in our case and committed to racing for the entirety of this season as we continue our fight to create a fair and just economic system for stock car racing that is free of anti-competitive, monopolistic conduct. 23-11 and Front Row will not lose their charter status immediately. The teams have 14 days to request that the matter be heard by the full panel of judges at the Court of Appeal. The ruling could take effect as soon as 7 days after the appeals deadline. In accordance with the decision of this court, the district court injunctions entered December 18th, December 23rd, and December 26, 2024 are hereby vacated, the court's order adds. This judgment shall take effect upon issuance of this court's mandate in accordance with FEDA R. App. P. 41. The ruling by Judge Niemeyer casts doubt on the case's antitrust merits. In entering a preliminary injunction in this case, the district court held that the plaintiffs were likely to succeed on the merits of their antitrust action against the National Association for Stock Car Auto Racing, LLC, NASCAR, and its CEO, James France, because NASCAR, as an alleged monopolist, required the plaintiffs, as a condition of doing business with them, to enter into a release for past conduct. Because that theory of antitrust law is not supported by any case of which we are aware, we conclude that it was not a likely basis for success on the merits and vacate the injunction. When the injunctions were granted last year, 2311 Racing and Front Row Motorsports argued that the ruling would maintain the status quo. NASCAR claimed to have modified the payment method for the 2025 season to accommodate a field of 32 charter teams rather than 36. The NASCAR case will proceed as scheduled, with a commencement date in December. The injunctions allowed 2311 and Front Row to compete for the two charters that they had in 2024. It did, however, allow them to obtain an individual charter from Stewart-Haas Racing. Without charters, the teams will be compelled to compete as open entries, incurring considerable financial losses. The U.S. Court of Appeals appears to have objected to the mandatory aspect of the injunctions. A prohibitory order, for example, alters the status quo rather than preserving it. Even worse, the court ruled that the team's antitrust accusations had no reasonable probability of success based on the circumstances of the case. In short, because we have found no support for the proposition that a business entity or person violates the antitrust laws by requiring a prospective participant to give a release for past conduct as a condition for doing business, we cannot conclude that the plaintiffs made a clear showing that they were likely to succeed on the merits of that theory. And without satisfaction of the likelihood of success element, the plaintiffs were not entitled to a preliminary injunction. We therefore conclude that the district court abused its discretion in entering the preliminary injunction that it did. This is all the more true in view of the heightened standard for issuing a mandatory preliminary injunction, and because the one here required two parties to engage in business that one party claims to be illegal. We express no view, however, on any aspect of the pending case beyond those stated herein with respect to the preliminary injunction. Accordingly, the injunctions of December 18th, December 23rd, and December 26th, 2024 are hereby vacated. The United States Court of Appeals did not feel the lower court's decision acknowledged any previous cases. In the circumstances where case law was invoked, the appeals court believed it was applied incorrectly. As a result, the teams will need to address this in their appeal. If the ruling is upheld, it will have far-reaching implications for the 2025 season. Losing charter fees could be a major issue for 2311 and Front Row for the rest of the NASCAR season. They have employees to pay, sponsorship contracts to manage, and race vehicles to build. This requires money. This decision will allow 2311 Racing and Front Row Motorsports to compete as open teams. They will have all 6 of their collective charters removed. This will affect the team's charter fees. It may also contravene the team's driver contracts and sponsorship agreements. I feel the most serious issue right now is what will happen to the Stewart-Haas charters. What if the acquisition of those vehicles is reversed? The Haas factory team has stated that they do not wish to and cannot accept 2 additional charters. They are currently a one-car operation. So, would NASCAR repossess them? Underperforming teams' charters may be forfeited based on their performance over the previous 3 years, if NASCAR so decides. Long story short, there is a big financial hit, potential contract violations with drivers and sponsors, and serious doubts about the Stewart-Haas charters. We'll see whether an appeal swings things back in favor of 2311 and FRM, but NASCAR scored a big win today. Moving forward, this affects the entire Cup Series. Other teams will now get a larger share of the charter money, at least in principle. It remains to be seen how NASCAR reacts to today's verdict. So what do you think? Will 2311 and FRM prevail in the end? Will they have to make major changes in 3 weeks? Let me know your opinions in the comments section below.